giving you an opportunity to speak to the council. Council, what's your client want to do? Let Ms. Hernandez interpret, please.
Está bien, volvemos al caso del señor Portillo. Señor Portillo, chicas, le di la oportunidad de hablar en una sala de consulta privada con su abogada. Señora abogada, ¿qué desea hacer su representado?
My client's going to bail himself with a recommendation.
Mi cliente quiere adherirse a tomar la recomendación de resolución hecha por la fiscalía.
The suspended license count will be amended to allowing an unlicensed driver to drive, and all other counts are being dismissed.
El cargo original de licencia suspendida va a ser cambiado a que no pudo presentar una licencia. Y los otros dos cargos van a ser desestimados.
You want to take the deal, sir?
Señor,
Yes.
¿esto es lo que usted quiere hacer? ¿Tomar este acuerdo? Yes.
Can you raise your right hand, please?
Por favor, ¿puede levantar su mano derecha, señor?
Yes.
You swear or affirm to tell the truth, whole truth, and nothing but the truth.
¿Usted jura o afirma decir la verdad, solo la verdad y nada más que la verdad?
Thank you. Yes.
Gracias. Yes,
All right.
thank you.
Put your hand down.
¿Puede bajar la mano?
Okay.
Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Señor, ¿usted entiende que la máxima penalidad para este tipo de delitos podría ser de hasta 93 días de cárcel y o hasta $500 de multa?
Yes.
Yes. Sí.
Do you understand that you have an absolute right to a trial?
¿Y usted entiende que usted tiene absolutamente el derecho de ir a un juicio si así lo quisiera?
Sí.
Yes.
Ms. Soroki went over your advice or rights in the breakout room, did she not?
Y mientras que estaba en la sala de consulta privada con su abogada, la señora Saroki, ella le explicó sus derechos también.
Yes. Yes.
Yes.
You understood those rights?
¿Y usted entendió esos derechos?
Yes.
Okay,
Sí.
who's that with you, sir?
Señor,
Hi,
¿quién es esta persona que está al lado de usted?
Es mi hija.
It's my daughter.
Okay, ma'am, what is your name, please?
Jacqueline.
All right, Ms. Jacqueline, your dad has to answer these questions on his own. If he doesn't understand the questions, I need to know that. You cannot answer the questions for him, all right?
I apologize. Okay.
You understood those rights that Mr. Soroki went over with you, sir?
Señor, ¿usted entendió esos derechos que la señora Saroki le informó?
Yes.
Yes, yes.
You have
Yes.
questions of rights?
¿Tiene alguna pregunta acerca de esos derechos?
No.
¿No?
Ay, no gano.
You know by taking the deal, you're gonna give these rights up?
¿Y usted entiende que tomando este acuerdo de resolución que le han ofrecido, usted está renunciando a esos derechos?
Yes.
Sí.
You're looking at your daughter again, sir.
Señor, nuevamente está usted mirando a su hija.
I'm sorry.
I'm gonna for you to come in person if I see it happening again, okay?
Si esto vuelve a pasar, yo le voy a tener que decir que se presente en persona.
Yes, I'm sorry about that.
Sí, me disculpo.
Let me draw your attention back to May 28th, 2025 at around 6:35 a.m. in the city of Detroit, the area of Clark and Toledo. Did you have an occasion on that day to come encounter with the Detroit Police Department?
Señor, déjeme llevar su atención al día 28 de mayo del 2025, después de las 6 de la tarde, en las inmediaciones de las calles antes mencionadas en la ciudad de Detroit. Ese día, ese lugar y en esa hora, ¿a usted lo paró un policía de la ciudad de Detroit?
Sí, sí.
Yes, yes.
Were you operating a motor vehicle?
¿Y usted estaba manejando un vehículo?
Folks, we're
Sí, sí.
recording, so keep it down.
Yes, yes.
Let's
Yo iba a trabajar.
Sorry?
Hello?
Did the officer ask?
All right,
Did
folks,
the officer
Hello?
ask
the
you?
only people that I'm looking to do is I have capuses in front of Judge McConico. So everybody else, and
Señor,
that will
tiene que
be, one
esperar.
will be attorney. Doesn't look like it. Right. So it doesn't look like any of them have attorneys, but we'll see.
Good morning, Magistrate.
Good morning, folks. Let me call Judge McConico. Counsel Scheid, you ready?
Yes, Your Honor, we're ready.
I don't have.
Courtroom
DD
533, Saran speaking.
Yes, ma'am, this is Magistrate Charter. Is this a courtroom for Judge McConico?
Yes, it is. Good morning, Your Honor.
Good morning, ma'am. I was gonna say we're ready, but I don't have
Okay.
DDC that has not signed in with us.
Okay, once DDC logs in, how many do you have,
Three.
Your Honor? Do you know? Three? Okay.
3 felony cases.
I'll let him know that it's 3 coming up, but can you have the clerk call back once they're on the Zoom?
Yes,
Okay, thank you so much.
thank you.
Okay,
Bye.
bye-bye.
All right, Ms. Kelly, can you call DDC?
Magistrate, would you do me a quick favor? I see that Mr. Torres is on defendant Zerzno. Would you mind if you just put us in a quick breakout room? Counsel, would you mind that?
Yeah, sure. Thank you.
All right, so I can do that. All right. Rakisha Sharad just stepped out. Okay. And Matthew Zidnell. Okay, just checking. No, just take a seat. I'm just checking. Emails. Thinking. In order?
I just was Sonia's leg. She stops being pissed out. Do think so. I think she placed them in order.
Okay. Walk in. Charles. Not in order. Break. Yes. Beresford. Brakefield, not here. Blake. Johnson. Johnson. Female. Yeah. Ethel. Talia, female. Here's
Gracias,
Ready as to
señor.
Mr. Lattimore, Your Honor.
This is at the bottom.
You said what?
We're ready as to Mr. Lattimore, Mr. Charles Lattimore from yesterday.
Let's call City of Detroit versus Charles E. Latimer. Case number SP 1699760, counts 1 and counts 2. SP 170000631. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Lattimore.
Charles Edward Latimer.
Your Honor, my client would avail himself of the people's offer to enter a plea to limit 1 to 5 as to the speeding matter, the remaining matters to be dismissed.
You want to take the deal, Mr. Latimer?
Yes, sir.
All right, stipulate to the face of the ticket as an active factual basis for that responsible plea on your client's behalf, counsel.
So stipulated, Your Honor.
Stipulate the probable cause for the dismissal of the other matter.
Yes, Your Honor, so stipulated.
Find your client responsible for the amended count of limited access 1 to 5. Allow Mr. Latimer to pay, he was here yesterday, $125, or you can lieu of fines and costs.
Owens, yes.
Okay.
Marianne Harris.
Okay. DDC, this is Magistrate Chartea. Who's the gentleman that I have in front of the camera?
Marianne Harris.
I'm sorry, what's your name, sir?
Marianne Harris.
Okay, Mr. Harris, you can step aside. DDC?
Yes, Your Honor.
Okay, I need these 3 individuals who are gonna go in front of Judge McConicle. Let me give you the names, or do you have a list? And I'll tell you the list number.
You have a list, Your Honor.
Okay, number 10, Mr. Owens. Number 13, Mr. Hardwick. Number 14, Mr. Dan.
Hey, Your Honor, bring them to the camera right now.
Okay, thank you. Mr. DeBose, okay.
Yes,
We will
ma'am.
get to you in a few minutes, so just be patient. We have
No
some
problem.
that need to go in order.
Yes, ma'am.
All right, the gentleman at DDC, what's your name, sir? Thank you, Mr. Owens.
We're gonna pick something else.
Ladies, can you call Judge McConaughey's courtroom? Okay, everybody, we're ready for him.
Okay.
And DDC,
Yes, Your Honor.
okay, just giving you a heads up, I'm gonna have to do Mr. Owens and Mr. Hardwick again for traffic matters. But we're just gonna do the felony cases first.
Judge McConaughey's court asks us for the cases that we require him to be placed at the back of the docket.
Oh, at the end? Okay, all right. DDC, it appears that for the cases that are gonna go in front of Judge McConaughey, Judge McConaughey wants to do them at the end of the docket. Okay.
Well, Your Honor.
So you want? So Owens, Hardwick, and Dan will be last of the list.
Who do you want now?
Let's do Mr. Harris.
Especially when I came close to
Gentleman in the black shirt, what's your name, sir?
Ariana Harris.
Mr. Harris, I'm magistrate at Champaster. You're here on a criminal matter, case number 250-455-2801. Counsel Shive, go ahead, ma'am.
Jessica Shive on behalf of Mr. Harris, who has formal reading, understands his constitutional rights and stands mute.
Thank you. I'm gonna enter plea of not guilty. Court date is July 7, 2025, pre-trial in front of Judge Jones. Mr. Harris, while this case is pending, you are not to have any contact with the Keon, York. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Further, you're not to possess any firearms or any other dangerous weapons. Do you understand those bond conditions? Okay. Counsel Vincent, go ahead.
Thank you, Magistrate. Good morning. Always a pleasure. Steve Vincent, 71917. Magistrate, with that condition, the people don't object to a personal bond, at least from what I can see. At least from what I can see, the defendant doesn't have any current cases. He doesn't have any prior convictions as well. So respectfully, with the no contact provision, no objection to person.
Okay. And Counsel Shive, any objection to a $5,000 personal bond?
No objections, Your Honor.
Thank you. Mr. Harris, you're gonna get a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that, sir? Do you understand that?
Yes, ma'am.
Thank you. That concludes your arraignment, sir. You can step aside. Thank you for your patience. Gentlemen, at DDC, what's your name, sir? Say it again, please.
Jalen Ford, Jaylin.
Is it Jalen Cornell Ford, sir? So thank you, sir. This magistrate at Chattapan, your criminal matter, case number 250-5833-101. You have an attorney, Counsel Shive. You wait for my reading, stand mute.
Yes, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are July 2nd, 2025, probable cause conference, followed by preliminary examination, July 9th, 2025. Both matters are in front of Judge Giles. Mr. Ford, let me give you some bond conditions. 1, you're not to possess firearms or any other dangerous weapons. 2, you're not to have any contact with the Keith Eric Ashford. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Counsel Coyle, you're here on behalf of the people, correct?
Good morning, Magistrate Lisa Coyle, appearing on behalf of the people. Good morning, Ms. Shive. Yes, Your Honor, the people in this matter are recommending a $200,000 cash surety bond. If he's able to make that bond, I'm asking for a tether house arrest. As the court has read, this just occurred on the 22nd, allegedly. I don't see a criminal history for Mr. Ford, but what this is a danger to the public as well as to Mr. Ashford. This involves road rage in which allegedly there was an altercation between drivers of Mr. Ford and Mr. Ashford on the freeway. He then followed the complainant's vehicle and he came to the side of the car and fired around into the vehicle of Mr. Ashford. Mr. Ashford gave the police a physical description as well as a description of the weapon used. He followed the car, got the plate, and got pictures of the defendant. The police did note a bullet hole to the driver's side window, which shattered the window. The plate came back to a Ford that was owned by the defendant, Mr. Ford, and it was not matching the vehicle that it was on. They went to his home, they arrested him. He not only made statements that implicated his involvement in the shooting, they recovered the gun from his person. That gun matched the description given by the complainant. On video was the defendant following the complainant's car. And there were many statements, as the court has read in the IR, and I'm not going to go through repeating them, but basically about, it sounds like Mr. Ford lost his temper and talked about shooting the guy and made several statements. So, Your Honor, I don't think this is a question of identity. It's very good as to the identification as well as to the statements made. But we also have not only a danger, this is road incident, which people in traffic every day have issues with other drivers, but you can't come out and pull a weapon. Mr. Ford is 25 years old. He's not a CPL holder. Even that does not give him a pass for firing a shot because of anger. Based on this, other people could have been hit. This man could have been killed. People believe he's a danger. That is why I'm asking for that 200,000 cash surety with a tether house arrest if he's able to make that bond, and all the other conditions, including no driving, imposed by the court. Thank you.
Thank you. Go ahead, Council Shive.
So, Your Honor, my client has no prior criminal history whatsoever, not on probation or parole, nothing pending, lives with his mom, lifelong resident, also is employed doing event planning with his mother, has an associate's degree, you know, has the family ties, community ties, never been in trouble to our knowledge or anything. Now, Your Honor, I understand the allegations and their seriousness, but they are allegations and he's presumed innocent unless proven guilty beyond a reasonable doubt. In the report, Your Honor, it does under excited utterance. It says that these statements were made by my client, if I'm reading this correct, because it says, Ford made several excited utterances before being transported, and they're caught on the body cam of the trooper, and they say, my client allegedly said, this man just literally flashed his gun at me. I almost got killed on the freeway. I almost killed myself, literally. It's all on my phone. He almost shot his pistol at me. He almost killed me. I have it recorded. He showed me his pistol and he tried running me off the road. So that's what my client was saying to the police as excited utterance. Those were the statements. So there are two sides to every story, and we don't know what was going on with these two drivers. And I know the report indicates that a gun wasn't found in the complaining witness's car, but with my client. But that doesn't mean there wasn't an incident or there wasn't a gun. Just because a gun is not found, people always argue that doesn't mean this situation didn't happen. So I'm going to argue the same thing here. And this is an individual who has no priors whatsoever, who's done everything right as an employed, associate's degree, lives with family, never gotten in trouble to our knowledge, no capious history, not at flight risk. With all that said, if the court is not inclined to release him on a personal bond without a GPS tether and house arrest, given the fact that you have these allegations in front of you and these serious allegations, then I would not be objecting to that only if he was to be given a personal bond, because I believe that way the court can ensure safety, not only to the complaining witness, who I don't believe they know each other, or to the public, although these are allegations and he's presumed innocent unless proven guilty beyond reasonable doubt, Your Honor, which I never asked for GPS tether and house arrest, but I understand the court has to weigh safety here. But I would ask for a personal bond, given what we have and what we don't have in the report, and given that there's no history whatsoever.
Thank you. I've heard the representations, both sides. Court uses clear and convincing evidence standard when it's entertaining a monetary bond. Okay, and this matter is just reading of the allegations in the investigation report and the arguments. It appears that there is a self-defense issue. However, that's for a trial court. The question is whether or not Mr. Ford is a danger of flight risk. I don't see him as a flight risk. Do I see him as a danger? Yes, I do. Allegedly, that firearm was flashed, according to the allegations, to Mr. Ford. Not that I heard anything that guns or he was shot at, but the reading from what I'm seeing is that, where is it? I want to make sure. He almost shot at me. Let's see. Literally flashed his gun at me. Okay. Not to say that he was shot at. The gun was supposedly flashed. Like I said, it may be a self-defense issue, but that's for a trial court. But the court still finds that Mr. Ford is a danger because had he had shot, and if the allegation is that he shot his firearm, then that could put other individuals, bystanders, in danger. So one, he's gonna be placed on a GPS, work only. There is no driving. Court is gonna adopt the recommendation, $200,000 cash surety, which I believe is unaffordable. Is that correct, Council Scheid? Council Scheib, is that correct or not?
Yes, Your Honor, that's unaffordable.
Okay, so, Mr. Ford, just so you understand, you do have another court date, and that's gonna be this Friday, June 27, 2025, 9 o'clock. It's gonna be in front of Judge McConigal. He's gonna look at the bond amount and he's gonna look at the bond conditions. Do you understand all that, sir? Okay, so I didn't hear you, so maybe the volume is set down or at DDC on their side, but I saw you shaking your head, I read your lips, and it sounds like that, or appeared that you understood everything. So you're gonna get another court date for this Friday, June 27th, sir, so you can step aside from the camera. Thank you, sir.
Wait. Your Honor,
Yes, sir.
quick question. So with this bond, would I be bonded out of here or would I have to go to the county to bond it out?
You'll probably end up going to the county, sir.
All right, appreciate it.
Thank you, sir. Let's see. Okay, hold on, let me do. Because I'm gonna forget if I don't write this down, the information. All right, Council Davis, I'm sorry, you were saying?
Ready on Rakisha Sherrod and walking.
Okay. There's, one has an attorney as a walk-in. Okay. Let's see, the gentleman in orange at DDC. Thank you, ma'am. What's your name, sir? Deshaun Blake? Is that a yes? Thank you. Mr. Blake, okay, DDC. Do you have a Mr. Watson and a Mr. Johnson? If you do, they're all three on the same case. Okay, all right, but Mr. Blake, okay, DDC, if you can bring Mr. Watson and Mr. Johnson to the screen. I'm gonna do traffic matters for Mr. Blake. Mr. Blake, you hear me? Is that a yes? Okay, DDC, I'm not sure if it's on your side or not, but don't hear Mr. Blake. So I don't know if the volume is turned up or not.
Hey, they're talking to you. We don't understand why you're not hearing them. We got everything up as loud as it can go.
Hold on. Ladies, you hear on the other side from DDC? We heard right now or before. All right, Mr. Blake.
Yes.
Okay, sir, this magistrate Chuck Dale, let me give you the misdemeanor matters. This is where you're gonna get a personal bond. Nobody has to pay any money for you to get out of jail. The maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. Let me tell you what they are. First ticket is P1124979, allowing unlicensed driver to drive. Next ticket is P1239026, driving unregistered untitled vehicle, driving while unlicensed. Next ticket is P1325683, which is no insurance misdemeanor, driver's license never acquired. Next ticket is P1488152, driver's license never acquired, no plates on trailer, no insurance misdemeanor. Next ticket is P1493245, driving while unlicensed. Next ticket is P1501092, driving unregistered untitled vehicle, no insurance misdemeanor, driving while unlicensed. Last ticket is P1599824, driver's license never acquired. Gonna enter plea of not guilty, sir. Court date is July 7th, 2025. It's pretrial in front of Judge Yancey. Mr. Blake, you have a right to remain silent. Anything you say orally or writing, it can be used against you in a court of law. You also have a right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, sir? Okay. So that takes care of that. Now let's gonna go over for the felonies. Mr. Blake, please say your full name, including your middle name. All right, the gentleman to your left, please say your full name. Okay, and the gentleman to Mr. Watson, please say your full name. Okay, Mr. Blake, you are defendant 1 in this case. Mr. Watson, you are defendant 2. Mr. Johnson, you are defendant 3. Case number is 250-58332. Okay, Counsel Shive, do you waive formal reading, stand mute?
Yes, Your Honor.
Okay, I'm gonna enter a plea of not guilty for all 3 gentlemen. Court dates are July 2nd, 2025. Probable cause conference followed by preliminary examination, July 9th, 2025. All 3 matters, excuse me. Both court dates are in front of Judge Jefferson for all 3 defendants. And gentlemen, for all 3 of you, you are not to go back to the location on Whittier, 10536 Whittier here in City of Detroit. Understand that, Mr. Blake? Understand that, Mr. Watson? Understand that, Mr. Johnson? Ladies, did you hear any of those gentlemen? Okay, so DDC, just so you understand, in case it was just me, I did ask the staff, and one of the staff members indicated that they did not hear the gentleman's responses, but from what I read and what it appeared is that they all understood the bond conditions. Okay, all right, Counsel Coyle, go ahead with your recommendation.
Good morning, Lisa Coyle, appearing on behalf of the people. Your Honor, as to the 3 men, I have different bond recommendations. This is a stolen truck that they used to break through the back wall of this business on Gratiot, Unique Fashions, and that allegedly Mr. Blake was the driver of that truck. As you can see from the investigator's report, he's the oldest. I would consider the other 2, Mr. Watson's 18, Mr. Johnson's 21. All were seen running from the location, and apprehended, Your Honor. I see as to Mr. Blake's criminal history, a 2011 attempt RCSP motor vehicle and a 2013 armed robbery. For his case, Your Honor, I'm asking for a 10,000 cash surety, also a tether to keep him away, and of course, no driving and no one to be back at the Unique Fashions on Gratiot location. As to Mr. Watson and Mr. Johnson, Mr. Watson's criminal history is a 2023 juvenile unarmed robbery. So he just turned 18 and now he's in adult court. So he had an unarmed robbery in juvenile court. I'm asking for a 5,000 cash surety as well as a tether on him. As far as Mr. Johnson, what I see is a 2023 disorderly. It was a R&L, pled down to the misdemeanor under height of status, Your Honor. This is, even though it's not assaultive, Your Honor, it is, as the court can see from the IR, the photographs, planned out. They went into this location, busted through the whole back concrete wall, and took items of high value from that location. So for those reasons, Your Honor, the people are asking for that cash surety bond as well as tethers for all defendants. Thank you.
Well, I'm sorry, maybe I missed it, but for Mr. Johnson, what was your recommendation?
Mr. Watson and Mr. Johnson, I'm asking for 5,000 cash surety with a tether, and of course, all the no contact provisions and so forth.
All right, Counsel Shive, go ahead, ma'am.
Your Honor, this is non-assaultive, as we heard. All 3 clients are presumed innocent unless proven guilty beyond a reasonable doubt. These are all allegations. So I am respectfully asking the court to consider high personal bonds, and I would not be objecting to a tether. No, none of them have any money to pay. Again, these are all allegations. Mr. Watson is 18 years old, and we just heard a unarmed juvie charged nothing as an adult. He's currently not on probation or parole or anything pending, and he lives with his mother, and he's employed. And he's also finishing the 12th grade, and he's a lifelong resident. So I'm respectfully asking the court to consider a personal bond, and I would not be objecting to a tether. I would ask the court to consider work and school only if possible, Your Honor. For Mr. Johnson, he is 21 years old, and he is currently looking for a job and unemployed, so he doesn't need to leave the house for any reason. So I believe if he was to be given a personal bond with a GPS tether and house arrest, although these are allegations and he is presumed innocent unless proven guilty beyond a reasonable doubt, that will take care of any concern that the court has. I'm not aware of habeas history for any of them. I don't believe they're a flight risk, but I understand that the court has to weigh community safety, even though these are non-assaultive. So for Mr. Johnson, he does not need to leave the house for any reason. I'm asking the court to consider a personal bond with GPS tether and house arrest. He lives with his mother, and he has a child on the way, and he's a lifelong resident, Your Honor. And he's not on probation or parole or anything pending. For Mr. Blake, Your Honor, although we heard prior criminal history, they do go back more than 10 years. We hear 2011 and 2013. I did not hear anything after that. We are now in 2025, so we do have age to all of those. And he's a lifelong resident of Detroit. He has 5 kids. He lives with his girlfriend and his kids. He is employed Monday through Friday, 6 a.m. to 2:30 p.m., and that's how he supports his family. So I know that the court has these allegations in front of him, but these are allegations, and they're presumed innocent again, unless proven guilty beyond a reasonable doubt. So, and they're non-assaultive. So, and I don't have any flight risk or habeas history. So I'm asking the court to consider personal bonds with tethers. And if for Mr. Johnson, he doesn't need to leave, but for Mr. Watson and Mr. Blake, if they'd be allowed to go to work and work only, we'd appreciate that, Your Honor.
Okay. One question, Council Coyle. Can you tell me on any of these, did any of the individuals, do they have a KPS history?
That I didn't have the time, Your Honor, to look up this morning based on the volume of the docket, so I apologize for that.
That's all
And
right.
so, like
All right.
as far as Mr. Johnson and Watson, one's HIDA, you can't see it. The other one's a juvenile. I don't access to juvenile records. And the other one is, the last one is the armed robbery. So he did prison time, and the KPS history would be old. So on these cases,
Okay.
I don't have much to go forward.
I
But there's no
appreciate it.
lack
Thank you.
of or any of it, I can say. Thank you.
Thank you. Court heard the representations on all 3 gentlemen in this particular matter. All 3 gentlemen are going to be placed on GPS tether. Okay, I'm not going to place any restrictions in this matter. Okay, the charge is non-assaultive. I do take everything into consideration. Okay, and I see that Mr. Blake, he had a matter from 2011. Okay, it appears non-assaultive. All 3 individuals are going to get $50,000 personal bond, along with the no address contact and GPS tether. That concludes your arraignment on all 3 matters. Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
And Your Honor,
Gentlemen at
already have
DDC, would,
sorry,
on who?
on the walk-ins whenever the court is.
Okay, all right. We'll get to them in a few minutes. The gentleman at DDC, what's your name, sir? I'm sorry, what's your name?
Larry.
So Your Honor, I think sometimes it's where they're standing for the camera. So if they move up a little or side, maybe the camera will catch the audio.
Possible. All right. Say your name again, sir. Is your last name Gerald?
No, it's Gilardi.
It's Gilardi. It's number 9, Your Honor.
Counselor, did you say number 9, Keith
It is.
Gerald,
It's
or no?
Keith Scott Gerald. He has an alias. It's Giraldi and as well as Giraldi.
So is it Keith Scott Giraldi? Okay, thank you, Mr. Giraldi. Trial Magistrate at Chattabaig, here criminal matter. Case number is 220-58901. You have an attorney. Counsel Shive, do you wait for a reading and stand mute?
Yes, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are July 2nd, 2025, probable cause conference, followed by preliminary examination, July 9th, 2025. Both matters are in front of Judge Jefferson. Mr. Giraldi, while this case is pending, 1, you're not to possess firearms or any other dangerous weapons. 2, you're not to have contact with these individuals, with a Cheryl Allison and a Robert Allison. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Let's see what else. And you are not to go back to the Neff residence. Do you understand that? Okay. With that being said, Counsel Coyle, go ahead, ma'am.
Lisa Coyle, appearing on behalf of the people. Your Honor, I know this is from March of 2022. And my recommendation on this matter is going to be a 10,000 cash surety, 10% with a tether. And I'm asking for an alcohol tether and no contact. The complainants in this matter are his mother and his stepfather. And I do note that he had come to their house. He had been drinking. He became violent. He grabbed a hammer from the complainant's pickup truck, forced his way through the front door, and raised a hammer and then tussled with the complainants. That he also swung the walking cane at the complainant, and he also bit Robert on his hand. The female, the mother, suffered a broken ankle that required surgery as a result of this. I do note his record. He right now currently is on probation out of Roseville for aggravated assault. It looks like he was sentenced in that matter May 21st of 25. I don't know who the victim is because this is, like I said, this is out of Macomb County. I do note another 2010 attempt R&O and DV conviction. And I also note substance abuse issues, 2007, 2009 possession cases of marijuana, 2012 OWI impaired, 2015 impaired, and recently a 2024 disorderly. And like I said, he's on probation right now for an assaultive crime. There was an APA note dated May 23rd of 25 in there. So this is very recent, and that the complainants are scared of him. So that is why I'm asking for that 10% bond. I'm also asking for an alcohol tether because there seems to be an issue regarding alcohol abuse, and because he's got 2 prior OWIs as well as on this date. Now I agree it's 3 years old, but this is his mother and his stepfather, and they said he was drinking. So there may be an issue. They're scared of him still as of May of 25. So I'm not, like I said, I'm not sure who the complainants in that aggravated assault case are out of Roseville. So for those reasons, that is what I'm asking, with all the no contact provisions, as well as no contact with the Neff Street address if they still live there. Thank you.
Counsel Coyle, I just want to make sure, is that you have new information, basically, is that contact has been made as of May of this year?
Yeah,
And that
I have it down as
okay.
May 23rd.
Okay, and that he's on probation for an assaultive behavior.
Correct. He's on
Okay.
Aggravated assault out of Roseville.
Thank you. Go ahead, Counsel Shive. Council Shive, if you're saying something. I mean, you're not muted, so.
Okay. Can you hear me now?
Yes, ma'am.
Okay, sorry about that. So this is now a case that's over 3 years old, and we're not aware of any incidents after. So I know that the people say that they have a note from May. I'm not aware of that. I haven't received that. I know that they maybe can't share that. However, when that was said, my client was shaking his head. No, I don't know. But if it was from May, that, you know, we're now June 25th. I didn't hear anything come after that. My client understands no contact. He's not living or having contact with his mother or anybody involved in this matter. And I am respectfully asking the court, given the age of the case, to consider a personal bond. And no drinking, I won't object to that. And if the court is not inclined to release him on a personal bond without a tether, I don't know how that's going to work, Your Honor, because he is going through a difficult time right now, and he is homeless because he can't stay with his family. He's not staying with his family. He's not having contact with his family. But this is a 3-year-old case, so he understands he needs to make it to his court dates. I didn't hear KP's history. I know he's not at flight risk. I know that people ask for either alcohol tether due to maybe alcohol being involved, but again, it's a 3-year-old case. So I would leave the rest up to the court, but I'm not aware of any incidents. I do know that he's on probation. I'm not aware of it being the same complaining witness or not. I know this is his mother and he understands the no contact. So at this time, given the age of the case, I'm asking the court to consider a high personal bond, absolutely no contact. And I wouldn't have objected to the tether, but he is homeless. So I don't know if you want to tether him to a shelter or something, but he's got nowhere to be tethered to.
Okay. Court has heard the arguments from both sides in regarding to Mr. Giraldi. Court uses clear and convincing evidence standard when it's entertaining monetary bond, started off with a personal bond basis. Now, this is, even though this case is approximately over 3 years old, okay, that's what I wanted to make sure. He's on probation for another assault of crime, okay? There is some notation indicated that as recent as of May of this year is that complaints are still afraid of him. Okay, so along with the bond conditions that I've already set is that Mr. Giraldi, there is no drinking, there is no possessing either alcohol, marijuana, or any illegal controlled substances. Do you understand that? Okay. With that being said, the court is also going to place him on a GPS tether. The court is also going to adopt the recommendation of $10,000 cash surety. And Council Shad, just so I understand this is going to be unaffordable. Is that correct?
That's correct, Your Honor. That's unaffordable.
Oh, thank you. So, Mr. Giraldi, while the court has given this bond amount and bond conditions, you're still going to have another opportunity for this Friday in front of Judge McConicle here at 36th District Court. He will look at the bond amount and bond conditions. It may stay the same. It may go up in terms of the bond amount. It may go different, lower. So he may look at everything and everything may be changed. And that may be Friday. That will be Friday, which is June 27th at 9 o'clock in front of Judge McConicle. Do you understand all that, sir?
All right, can I say something?
You can, sir. You have the right to speak, okay? But understand, everything that you say is being recorded.
I understand that. What they're saying,
Sir, anything you say right now, Ken, will be used against you. It's all part of the record, but you do have a right to speak. So I can't stop you, but as your attorney, I would advise you to not make any statements because there are prosecutors on and it's all part of the record.
what they're saying is completely false. There was no call. I was talking to my stepdad. He was standing in the doorway. My mom came out of the area right.
Sir, you're about to, it's all part of the record and there's prosecutors on. Again, you have a right to speak. I can't stop you, but as your attorney, I'm going to advise you to be cautious and probably best for you to not say anything at this time.
Okay, I'm not gonna talk to you guys later. Thank you.
All right. Thank you, Mr. Giraldi. You can step aside. You have a Brakefield? I didn't see any files on Brakefield. There's 2 files listed. Gentlemen at DDC, what's your name, sir? Maybe at where you're standing, sir, but what's your name?
What's it, Brakefield?
Okay, Mr. Brakefield, this is Magistrate at Chartea. Stand by, sir. Let me see. This goes to Mr. Dan. I have no files. Mr. Brakefield. Possibly took them off? Okay, so Mr. Brakefield, we're gonna have you step aside. DDC, we don't have any files on Mr. Brakefield at this moment. We're gonna be looking for those. So we will get back to Mr. Brakefield. Okay, close. What happens to the file on Mr. Air? All right, the gentleman in orange, what's your name, sir?
Stephen Hardwick.
I'm sorry, say your last name again.
Wait.
Your Honor, that's one of the
Number
following
13.
capious matters, Mr. Hardwick.
Hardwick? Okay, sir, is your last name Hardwick? Okay, sir, you can step aside. At the end of our docket, we will be doing with you. Let's see. Okay. DDC, we're gonna ask you to stand by because it looks like we're missing some files. Okay, let's see. All right. I have folks. Let's go. Okay, Mr. DeBose.
Yes, ma'am.
Okay, all right, sir. This is Magistrate Chartea. Tonto Shaib, you ready on Mr. DeBose?
Your Honor, the Register of Action says that his attorney filed an appearance.
I don't have anything to indicate that
Sir,
there
you hired
is, who's the attorney?
Say that one more time, ma'am, please.
What's your attorney's name, sir?
Mark, I'm sorry, 1 second. Mark,
And
please.
he filed an appearance in the Register of Actions, Your Honor. That's why we didn't touch it.
Yeah, it's Mark, McDougalson, Gredison, something like that. I'm sorry.
Counsel Shaib?
He was in
the
court.
attorney name?
I'm sorry, yes, Your Honor. I can get you the exact phone number and name from the Register of Actions.
What's his last name? First name is Mark.
1 second.
Your Honor, Attorney Mark Magnus's office called, they just called and said that he's in court, he'll log in as soon as he gets done.
Okay, well, Mr. DeBose, apparently we're being
Yes, ma'am.
told that your attorney is in court, so we're gonna put you at the very end. You will log in, so we're gonna
Okay.
move on to some other things. We'll put you back in the waiting room.
Yes, ma'am.
Thank you. All right. Let's do Matthew. And we should have an attorney. Torres.
Yes, Your Honor.
All right, first of all, let's see. Sir, do me a favor, please say your full name.
Matthew James Chanel.
Okay. Council, go ahead. Council
Yes, Your-
Torres.
Yes, Your Honor. Good morning. My name is Peter Torres. My P number is 68242. This is an arraignment. We'll waive formal reading. My client will stand mute.
Thank
I'll ask
you.
the court. Thank you.
Thank you. I'm gonna enter plea of not guilty. Court dates are July 2nd, 2025, probable cause conference. That I believe is at 8:30, followed by preliminary examination, July 8th, 1:45 PM. Both matters are in front of Judge Shakay. Mr. Matthew Zernell?
Yes, Your Honor.
Okay, so while this case is pending, you're not to go back to Comerica Park. You understand that? All right. Council Vincent, go ahead with your recommendation, please.
Thank you, Magistrate. Good morning. Steve Vincent, P71917. In full candor to the court, the reason for the breakout room with counsel was to let him know. I knew that this was a walk-in, but I was still going to be asking for cash here. I was going to be asking for an alcohol tether as well. Quite honestly, I told counsel that this defendant's pretty lucky that he retained Mr. Torres, because if he hadn't, I was going to ask for a lot more. But because he had, I'm only going to be asking for a 5,000, 10%. I am going to be asking for that alcohol tether as well. These allegations are egregious. He's being charged with the CSC 4th. He's being charged, I don't know whether or not he also has that adjacent A and B. But at the very least, it's the CSC 4th, a high court misdemeanor, the 2-year misdemeanor. Here we have a defendant at the time, allegedly a patron at the Tiger's Den in Comerica individual
that.
who was grabbing somebody's, body area, but I don't think if you're talking about a rape exam or anything like that, no.
Or anything to the extent that there was bruises.
I don't know how hard he grabbed her behind, but I don't think she ended up having to go to the hospital as a direct result of that.
Judge, I have a
Thank you.
report. I'll answer that. The answer is no.
Okay, so in this case, okay, so Mr. Zernell, $50,000 personal bond, you're supposed to stay away from Comerica Park. Don't even, well, you know what? Comerica Park and Ford Field. Basically, I don't want you going to any sporting events locations. Those are the two main ones that I know. Sure, if you're caught just with alcohol, okay, on your person, okay, understand that it's a bond violation. Okay, so.
Understood.
Because this is the one shot that you have, sir. If there's any violation, sir, then you're gonna be looking at a monetary bond. You understand that?
Yes, Your Honor.
Okay, $50,000 personal bond. Nobody has to pay money for you to get out of jail if you were sitting in jail. Do me a favor, sit down, wait for your paperwork.
Thank you, Your Honor. Thank you, Mr. Vincent.
Oh, you got
Thank
it.
you.
All right. Thank you, Magistrate. You guys take care. You guy.
Let's see, Heard. Heard, please step forward. What's your full name, sir?
Dayon Hurd.
Is it Dayon Corday? Heard? Thank you, Mr. Heard. I'm magistrate. I checked that. Case number is 250-4479301. You have an attorney, Counsel Shive. You wait for my reading and stand mute.
Yes, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court date is July 7th, 2025. Pre-trial in front of Judge Jones. Let's see. Okay, Mr. Heard. 2, there is no drinking, no possessing of any alcoholic beverages. And there is no driving without a valid driver's license. Do you understand those bond conditions?
Yes, ma'am.
Okay. Counsel Coyle, go ahead, ma'am.
Lisa Coyle, appearing on behalf of the people. Your Honor, I'm not aware of any priors for any alcohol or drug offenses, and nothing subsequent to this. This occurred back in April of 24, was not signed till March of 25. This was some speeding and traveling out of the lanes. I see a breath ticket for 11s. So based on that, Your Honor, with the conditions the court has imposed, no objection to a $15,000 personal bond.
Thank you. Not hearing any objection from your attorney, so you're gonna get a $15,000 personal bond, meaning had you been sitting in jail, nobody would have to pay any money for you to get out of jail. You understand that?
Yes, ma'am.
So all you gotta do, sir, is just take a seat, wait for your paperwork, okay? Thank you, sir. Sherrod, please step forward. Okay. What's your full name, ma'am? Sorry, say it. Okay. Tisha Tainita Sherrod. Okay, thank you, Ms. Sherrod. I'm magistrate at that. Not only do you have a criminal matter, but you also have a misdemeanor matter where you did not show up for court. You're gonna get a personal bond on that. We're gonna recall the warrant. The maximum penalty on the misdemeanor, ma'am, is up to 93 days jail and or $500 fine. The ticket number is P1409217. It's drawn while licensed, not valid or improper license. When enter plea of not guilty. Court date is July 8, 2025. Pre-trial in front of Judge Archer. All right, Ms. Sherrod, you have a right to remain silent. Anything you say orally or writing, it can be used against you in court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, ma'am? Okay. Let's see. That takes care. So that takes care of that. Yep, I signed that one. So let's go with criminal matter. Case number is 250-4545601. Please say your full name again, Ms. Sherrod. Council Shive, you wait for Marie, stand mute.
Yes, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court date is July 8th, 2025, pre-trial in front of Judge Bryan. So let's give you some bond conditions. You are not to go to, well, first of all, you're not to have any contact with Manifa Davis. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Okay, you're also not to go to the mobile gas station that's located at 5944 East Davison. Do you understand those bond conditions? Okay. Council Vincent, go ahead, sir.
Thank you, Magistrate. With those conditions, we're not going to be objecting to a personal bond. She walked herself in today.
Okay, thank you. No objections, that means you get to walk yourself out. You're gonna get a $10,000 personal bond. Nobody has to pay any money. If you've been sitting in jail to get out of jail. You understand all that? Okay, so all you gotta do, ma'am, is just take a seat, wait for your paperwork. Thank you.
Did the judge give the,
Okay, Parker. All right, let's see. Okay. Council Shive?
Yes, Your Honor.
Just want to make sure, you had made no contact with the Department of Corrections, is that correct?
That's correct. They usually call into the court. We haven't made contact with them.
Bless you. Sure. Ladies, can somebody call, find out on Parker, if they're supposed to be calling us? Bless you again. Sonia?
Yes.
Okay, can you check? No, this is the Department of Corrections.
Oh, okay.
Okay. Yep. So we'll wait.
Magistrate, just so you know, I mean, I don't know if the court and Ms. Shive, if you guys would be willing to do this, but I'd stipulate to waiving her presence. She doesn't have a release date until October 3rd. So, I mean.
You're talking about Ms. Parker from the Department of Corrections, correct?
Yeah, so I'm just going to be asking for a personal.
Okay, however, that is, Council Shive, Ms., I don't know if you have any objections or not, but also Ms. Parker has traffic matters. She'll get a personal bond, but.
And we haven't interviewed her to let her know what's going on either, but.
Okay, all right.
Thank you.
So Brakefield. All right, so we're gonna call. So we gotta do that. Let's see, who's this? Let's see. All right, Mr. DeBose, please unmute.
Yes, ma'am.
Okay, is it Mark? Your attorney is Mark, Magidson?
Yes. that's
Thank
me.
you.
Thank you.
Okay,
I'm here.
hold on for a moment. Counsel? What's your P number, sir?
25,581.
That's earlier, so you've been practicing, that's great.
Well, I was started off in a different century.
Yes, me too. All right, let's see what we have. Okay, Mr. DeBose, please say your full name.
Carlos Relette DeBose.
Thank you, Mr. DeBose. Case number is 250-5801-001. Counsel, go ahead, please.
Good morning, Your Honor. Mark Magidson on behalf of Mr. Carlos DeBose. Judge, we would waive the formal reading and stand mute as to these charges. Ask a pleas of not guilty be entered.
Thank you. I'm going to enter a plea of not guilty. Court dates are July 3rd, 2025, probable cause conference, followed by preliminary examination, July 10th, 2025. Both matters are in front of Judge Giles. Okay, so we have those.
What was the
Say
second
some
date?
bond
Judge,
conditions.
what was the second
Sure,
date?
I'll give you the dates. July 3rd and July 10th, in
Thank
front
you.
of Judge Giles. Mr. DeBose, let me give you some bond conditions. There is no drinking or possessing any alcoholic beverages. There is no driving, okay, of any motor vehicles, no golf carts, no motorcycles, no mini bikes. You understand all that, sir?
Yes, ma'am.
Okay, all right. Counsel Coyle, go ahead, ma'am.
Good morning, Lisa Coyle, appearing on behalf of the people. Good morning, Mr. Magnuson.
Morning,
Nice to
Lisa.
see you.
Good to see you too.
This, Your Honor, this involves the defendant allegedly driving the wrong way down the Southfield and striking a car head on. One complainant had suffered from a fractured hip, another one had fractured legs and a dislocated hip. His breathalyzer was a 0.209. Now, he is on Zoom, so flight, and he also has a retained lawyer, so flight is not a concern. The court did impose no driving and no alcohol, which those restrictions. Normal, if he were here, I would be asking for a 25,000, 10%. I'm leaving that to the court's discretion because this is so incredibly dangerous to the public. And these complainants are lucky they were not injured more severely as a result of the crash. And Your Honor, I am asking for him to have to turn himself in for an alcohol tether. This just occurred March 9th of 25. His alcohol level is incredibly high, 0.209. I know that the restrictions, the conditions the court put on no drinking, no driving, well, he shouldn't be doing that in the first place, and we wouldn't have been here if he abided by those conditions of the law to begin with. Unfortunately, people believe that they can get behind the wheel of a car and drive it responsibly, even though they're drinking. And the law allows it within certain limits, but not here. This is a blatant disregard of on the wrong way of a freeway. So, and especially the Southfield, because there's nowhere to go. It's a very, very old freeway and it's very tight. So for those reasons, Your Honor, I'm asking for that bond, and I am asking the court to have him turn himself in and get an alcohol tether in addition. Thank you.
Thank you. Go ahead, counsel.
Judge, it wasn't clear to me what the prosecution was asking. Was she asking for a cash bond in addition?
I asked for 25,000, 10%. As well as an alcohol tether and all the conditions the court has already imposed. Thank you.
Okay, thank you. Well, Judge, this is a situation where my client does have a mitigating circumstances here. He has a history of seizure disorder. That's not any better. I'm just indicating, and that we believe that what was going on here was a seizure disorder that was going on. Having said that, my client is working at Chrysler for the past 10 years. He's got no prior criminal history. He's lived in Detroit all his life. He's raising two sons. He's got a fiance. They live together. He lives a normal life. This is a totally aberration in terms of who he is, what he represents. And we believe that once we further investigate this case, it'll be shown that the circumstances aren't as bad as they appear. So we have no problem with the judge's, the court's restrictions, no driving, he's not driving. And we have no problem, with even an alcohol tether, if that's what the court wants. There's no need for an additional cash bond, Your Honor.
Counsel Coyle, is this the first time of drinking and driving?
I am not aware of any other priors or subsequent to this, Your Honor.
Okay, thank you. All right. So I
Your
did
Honor,
see
Your Honor,
Mr.
we lost Mr. Magnuson before you go forward.
Thank you. I did.
Okay.
25581.
Thank you.
Yes, ma'am. As we're doing that, Counsel Franulik, please unmute.
Yes, Your Honor.
Ma'am, who do you have?
I have Donovan Freeland. I had logged in earlier to see if he was set for arraignment today. I didn't get a response at the DDC. I did get notice that a warrant was sent for him, so I thought he would be arraigned. So I figured it was better for me to come and wait than to miss it.
Okay, I appreciate that, ma'am. And I'm sorry that I didn't get to you sooner, but there is no Mr. Freeland or Miss Freeland. There is nobody by the name of Freeland on this morning's docket.
Okay, I'll just check back for the afternoon docket. Thank you very much, Your Honor.
Thank you for your patience. Thank you, ma'am.
Of course.
Counsel, please unmute.
Sorry, Judge, my computer went dead.
All right, all right. All right, so I heard your argument. I heard the prosecutor's argument. This is drinking and driving. From what I understand is he has no other prior drinking and driving incidences. This is from March of last year. So he is in by Zoom. I did see him and it looked like he was either on a bicycle or he was walking earlier. Okay, I didn't see him that he was in a motor vehicle. So I'm gonna give him an opportunity, okay? Mr. DeBose, you're gonna get $100,000 personal bond. Nobody has to pay any money for you to get out of jail. You understand the bond conditions that I gave you, sir?
Yes, ma'am.
Okay, so, sir, if you're caught with a bottle of liquor, a bottle of beer, a bottle of wine, because it's not just the drinking. I'm telling you right now, okay? You're not to possess any alcoholic beverages. If somebody
ma'am.
says, hey, can you hold this can of beer? Can you hold this drink, this mixed drink? If you're caught, you're found out, violation, you're gonna be looking at a monetary bond next time. Do you understand that, sir?
Yes, ma'am.
Your Honor, I just like to correct the record. This was March of this year, not last year.
Okay, all right, I apologize. If I said if it's of last year, it's March of this year. So $100,000 personal bond, no drinking, no driving at all. Okay, want to make sure that no possessing of any alcoholic beverages. That conclusion of Mr. DeBosa's arraignment.
Thank you, Judge.
Thank you.
Thank you.
Mr. DeBose, I'll be in touch with you. I'm in a trial right now, but I'll call you later today.
Yes, sir.
Okay, bye.
That takes care of that. Did anybody contact the Department of Corrections? Not yet? All right, let's do Department of Corrections. Let's do the rest of BDC.
Can I ask, Your Honor,
I don't have the file on Parker.
no, this is, in regards to mechanical, he's gonna be like 20 minutes out. So,
Well, we got 3 more cases. If he wants to do it right now, we can.
no, he can't do it right now, he's about 20 minutes
Okay, it's 20 minutes away.
at least.
Okay, that's fine.
Okay, I guess it'll be great, but we're not ready, anyway.
All right, BDC. Can you unmute?
Got it, yeah, they got it.
DDC, can you hear me? I see you're not muted, but I don't see you visually.
I've said it 3 times. Can you hear us?
I can hear you. Now I can see you. Yes. Judge McConicle is not ready for those 3 capuses, but I do have files on a Mr. Ayers and Mr. Brakefield. No, no, she just told me that. Okay, I'm sorry, DDC, what'd you say?
Vincent McLeod.
The cloud. Okay. I don't have a file. Folks, you know what happened to a McLeod file? Yep, last page. Okay. All right. We don't have the McLeod file, but I do have a Mark Ayers and a Martius Brakefield files. Gentleman in yellow, what's your name, sir?
Mark Antonio Ayers.
Thank you. Mr. Ayers, I'm Magistrate Chartea. Not only here on a criminal matter, but you're also here on misdemeanor matters. These are misdemeanor matters that you did not show up for court. You're going to get a personal bond. We're going to recall the warrants. The maximum penalty on each misdemeanor, sir, is up to 93 days jail and or $500 fine. You understand everything I've said so far, sir? Yes. Okay. Let me tell you what the tickets are. P1098714, drive while license suspended, no insurance misdemeanors, improper plates. Next ticket is P1291704. No insurance misdemeanor. Last ticket is P1704170. Let me repeat this. P1704170. Drive while license not valid and improper license. I'm going to enter a plea of not guilty. Court date is July 9th, 2025, 1:30, courtroom 533. Let me repeat that, courtroom 533. Personal bond, Mr. Ayers, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, sir? Okay. All right, let's start off with your criminal matter. Case number 190593841. Please say your full name again.
Mark Antonio Ayers.
Thank you, Mr. Ayers. Okay, Counsel Shive, you wait for my reading, stand mute.
Yes, Your Honor.
I'm gonna enter a plea of not guilty. Court dates are July 9th, 2025. It's an in-person hearing, sir, 9 o'clock at the Criminal Justice Center at 5301 Russell Street, City of Detroit. It's in front of Judge Prentice Edwards. Do you understand that? You also have a preliminary examination, July 16, 2025. We'll see what happens with that. Counsel Coyle, let's see. It doesn't appear that this is a Attorney General case.
No, it's ours. Lisa Coyle appearing on behalf of the people. Your Honor, this is about 13,000 in arrears. No objection if good cause is shown to a 5,000 personal.
Okay. All right, Counsel Shive, any objection?
No objections to a personal bond, Your Honor.
Thank you. In this particular matter, court is required to have at least 25% child support arrearage. 25% is approximately $3,000. So you're going to get a $3,000 personal bond. Mr. Ayers, that means nobody has to pay any money for you to get out of jail. Do you understand all that? Okay. Are you shaking your head? Yes?
Yes.
Okay. Because your audio, your volume, it's going in and out. So I hear a little bit of what your response is. So anyways, $3,000 personal bond. That takes care of you, Mr. Ayers. You can step aside.
Thank you.
Sonia, you know what happened to Mr. McLeod's file? No, we're trying, you know, let me go and see if Yo, has the tickets, because she kept the file. All right. Let me just double check, yeah, because they're not answering. But, Ms. Jackson, she's working on this NPLC, okay? Okay. All right, stop right there. Let's see if I have. No cloud. Okay. Okay. All right. EDC, if you have Mr. Brakefield, that'd be fine. We're still working on the McLeod file.
Yeah, that ticket's on. I know she said he has a lot and she'll bring them in. once she
Okay.
gets it, Your Honor. I remember that part.
All right.
That's supposed to be her.
Sir, what's your full name?
Murray.
Last name Brakefield, correct?
Yes, ma'am.
Mr. Brakefield, I'm magistrate at there. You have 2 criminal matters, but you also have a lot of misdemeanor matters. Misdemeanor matters, we're going to recall the warrants. You're going to get a personal bond. Nobody has to pay any money for you to get out of jail on the misdemeanor matters. Maximum penalty is up to 93 days jail and or $500 fine. First ticket is P1183473. Driver license suspended, no insurance misdemeanor. Next ticket is P1568324. Trespass. Next ticket is P1588802. Trespass. Next ticket is P1598673. Possession of drug paraphernalia prohibited, disobeying lawful order of police officer. Next ticket is P1607301. Trespass. Next ticket is P1607319. Possession of drug paraphernalia prohibited. Next ticket is P1665252. Trespass. Last ticket is P1699824. Trespass. Loitering. Disobeying lawful order of police officer. Sir, I'm gonna enter plea of not guilty. Court date is July 7th. Hold on. Ms. Sonia?
Yes, Your Honor.
Okay, on the traffic matters, I got July 7th, and on the criminal matters, I also have July 7th.
Okay, you're gonna change that.
One that is in front of Judge Yancey, the traffic matters.
July 14th, Your Honor. For the
Okay.
traffic.
Yep. All right, so you're gonna get July 14th, sir, pre-trial in front of Judge Yancey. Mr. Brakefield, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Okay, now, let's go, Mr. Brakefield, your criminal matters. Both are misdemeanors. You're gonna get the same court date. Let's start off. Case number is 240-4484101. It is retail fraud, 3rd degree, from June 2nd, 2024. Next case is 25044330001. It is from January 30, 2025. It is retail fraud, 3rd degree. Counsel Shive, you wait for my reading and stand mute.
Yes, Your Honor.
I'm gonna enter plea of not guilty. Court date is July 7th, 2025. Pre-trial in front of Judge Bryant. Okay, Mr. Brakefield, you're not to go back to the Amico gas station. It is the same location, which is 14444 Finkel City, Detroit. Do you understand that bond condition, sir? Is that a yes? Okay. That being said, I don't see anything to indicate that there were capuses. Counsel Vincent, go ahead, sir.
Magistrate, we're doing both of them, right?
That is correct.
He has 6 capuses in
That's good.
the case ending in 4841. Never been arraigned on the other matter ending in 4330, but he was, while failing to appear on the prior case, he ended up allegedly picking up this case. He's got 110% on that the 24 case with the offense date of June 2nd. It appears as though he's never taken this case seriously. The only times he's appeared for court is when he's arrested on warrants. He's previously posted and then failed to appear. He's gone to redetermination and then failed to appear at the following hearing. It's 110%. We would be asking you to continue that. We would ask for monitorization. And then due to the flight risk that he's displayed based on the case ending in 4841, we're not going to object to a personal on the new case, but we would be asking for monitorization on that as well.
Council Shive, go ahead, ma'am.
Your Honor, I feel like if Judge Bryant wanted to add a tether, she would have, and also if she wanted to make it unaffordable, she would have. But 110% to most people's affordable because it's $10. Unfortunately, to my client is not. These are non-assaultive. He's not on probation or parole, nothing pending. He lives with his grandma, who he takes care of. And I'm asking the court to consider personal bonds on both matters without a tether, and we have updated contact information. He's been in custody for a couple of days now. He understands that he does not want to be in this situation, and he's only in this situation because he missed court. He indicated he thinks he was in the hospital. However, I do understand that there was multiple capiases, and we understand that, and we get that, Your Honor. We've had the conversation. One is from 2024, and one is allegedly from January. We're now in June. We're not aware of any more incidents with this place or this location or any new cases. So I'm asking the court to give him one last chance, high personals, no moderate, no tethers, and he'll be at his court dates. If the court is not inclined to do that on the one that he missed court, then I ask the court to keep the bond as is and don't add a tether, $100, 10%, Your Honor, although it's unaffordable to him.
Thank you. Mr. Brakefield, I'm going to give you one last chance. Judge Bryant has given the court authority to modify her misdemeanor capiases. So on case number ending in 84101, where there is $100, 10%, I'm going to give you $1,000 personal bond. That is the last chance that you're getting from this court. You need to go to court, handle your matter. Do you understand that, sir? Is that a yes? Okay, I see you shook your head. And as to the other case that you've never been arraigned on, ending in 33001, you're going to get $1,000 personal bond. Let me repeat that. $1,000 personal bond. For both cases, it is personal bond. Okay. This is your last chance, sir. Any violation? Don't come asking for any mercy, because this is your last chance. $1,000 personal bond on both matters.
Your Honor, are both
Go
his
to court
court
and
dates
handle your
the same?
matter.
Are both
Pardon
court
me?
dates the same? Are both court dates on the same date? Okay. Thank you.
Yep, July 7th. All right, so that regards Mr. Brakefield. Let's see who else. Okay, all right, okay. BDC, can you bring back Mr. McLeod?
McLeod? McLeod?
Yes, McLeod.
Stand on the line. I don't have a Vincent McLeod.
Mr. McLeod, if you're there, I don't see you in front of the camera. Here's Mr. Breakfield's paperwork on the traffic matters. Here's Mr. Breakfield's paperwork on the traffic matters. I would just wait for Mr. McLeod.
They're right there in the line.
Sir, what's your full name?
McLeod.
Is it Vincent Ardes McLeod, sir? Is that a yes?
Yes.
Thank you, Mr. McLeod. Magistrate Charte, you have a number of traffic matters where you're going to get a personal bond. Nobody has to pay any money for you to get out of jail. The maximum penalty on each misdemeanor is up to 93 days jail and a $500 fine. Let me tell you what the misdemeanor matters are. First ticket is P833399. It is, those are civil infractions, doesn't apply. Next ticket is P843800, drawn while license suspended. Next ticket is P1623131, which is driving commercial motor vehicle with no license in possession, drawn while license suspended, repeat offender. Next ticket is U55823320, disorderly conduct. Next ticket is U660597723, alcohol-related violations. Next ticket is U66381423, disorderly conduct, public intoxication. Next ticket is U688304424, disorderly conduct. Next ticket is U71240425, disorderly conduct. Next ticket is Z8058391, operating while intoxicated, first offense city. Next ticket is 194298081, drawn while license not valid or improper license. Next ticket is 217260361, disregard an officer signal. Next ticket is SP 8438001, drawn while license suspended. Next ticket is SP 162-31311, driving commercial motor vehicle with no license in possession. Count 2 is drawn while license suspended, repeat offender. Next ticket is U55823320, disorderly conduct. Looks like those are the tickets. I'm gonna enter a plea of not guilty. Court date is July 7, 2025, pre-trial in front of Judge Wagner. Mr. McLeod, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights? Okay, that concludes your arraignment, sir. You can step aside. Okay. BDC, Judge McConicle hasn't signed in, but it appears Mr. Owens, Mr. Dan, and Mr. Hardwick, they all have traffic matters. If you want, we can do the traffic matters first.
Come on, I'd like one.
Sir, what's your name?
Stephen Hardwick.
Stephen Monroe Hardwick, sir? Mr. Hardwick, I'm just gonna do the traffic matters. We're waiting for Judge McConicle so he can do the arraignment on the felony cases, but anyways, let me tell you, we're gonna recall the warrants, you're gonna get a personal bond, nobody has to pay any money for you to get out of jail on the misdemeanor matters, you're gonna get a personal bond. Maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. First ticket, sir, is U455697118, disorderly conduct. Next ticket is P11511605, driving unregistered untitled vehicle, driving while unlicensed. Next ticket, sir, it is U38984917, disorderly conduct. Next ticket is U4551718, alcohol-related violations. Last ticket is T479, consuming alcohol in public. Court's gonna enter plea of not guilty. Court date, sir, it is July 8th, 2025, pre-trial in front of Judge Millhouse. Mr. Hardwick, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to court an attorney, one will be appointed for you, court expense. Understand those rights?
Yeah.
Okay, thank you, sir. So you can step aside. We're just waiting for Judge McConicle. Okay, then we'll do your criminal matter.
Should I just call to make sure, yeah, let me just call.
Okay. Because I heard it was 20 minutes out, so I would assume that he'll come back. All right, the gentleman in blue, what's your name, sir?
Here.
Joseph Wiley Dan. Mr. Dan, I'm Magistrate Chartea. You do have a criminal matter that'll go in front of Judge McConicle, but on the misdemeanor matters, you're gonna get a personal bond. Nobody has to pay any money for you to get out of jail. Maximum penalty is up to 93 days jail and or $500 fine. First ticket is P1493363, which is Drumbo license suspended, no insurance misdemeanor. Last ticket is P929480. It is failed to display valid driver's license, not on person, driving unregistered untitled vehicle. Driving unregistered untitled vehicle, no insurance misdemeanor. I'm going to enter plea of not guilty. Court date is July 8, 2025. Pre-trial in front of Judge Sherman. Mr. Dan, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to court an attorney, one will be appointed for you, court expense. Understand those rights? Thank you, sir. You can step aside.
They want him to be on the screen, Your Honor, before I call back. I just called to let them know, to come on, but they said, make sure he's on the screen first.
Okay, let's do this one last one. Traffic matter. Okay. Is your name, what's your full name, sir? Rama Jade Owens, sir?
That's Rama J. Owens.
Thank you, Mr. Owens. I'm Magistrate Chartea. Not only do you have criminal matter, but you have misdemeanor matters. I'm going to do the misdemeanor matters right now. You're going to get a personal bond. Nobody has to pay any money for you to get out of jail. The maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. First ticket is P1350385, disorderly conduct, consuming alcohol in public. Next ticket is P1482403, urination, defecation in public. Next ticket is U39974317, disorderly conduct. Next ticket is U598229121. It is disorderly conduct. Last ticket is U611555521. It is entering without owner's permission. I'm going to enter plea of not guilty. Court date is July 8th, 2025. It is a pre-trial in front of Judge Perkins. Mr. Owens, you have a right to remain silent. Anything you say or or writing, it can be used against you in a court of law. You also have a right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights? Okay, stay there, Mr. Owens. Can you call Judge McConicle and let him know that we have the individuals and we have Mr. Owens who is on screen?
Okay, Mr. Owens, okay, thank you.
And then we can do the other two also. So DDC, after Mr. Owens, we can do Hardwick and Dan, all three matters. As soon as Judge McConicle gets on the screen. Nope.
Okay, thanks so much. Okay. Couldn't tell me, no one's answering.
Okay. That is for Parker. All right, so we're not gonna do anything with Parker. Here we go. Judge McConicle, we have three cases. The first case is case number 250-577-8801. It is People of the State of Michigan versus Rama J. Owens. Date of offense is May 21st, 2025. Charges counts 1 and 2, which is weapons found possession by prohibited person. Count 3 is carry concealed weapon, pistol on person. And count 4, carry concealed weapon, pistol on person. Count 5, 6, each count is weapons felony firearm. There's an habitual second offense notice, and the KPS is June 20th, 2025, $1,000 cash surety.
Right. Appearances.
Chief Judge McConicle, always an honor, always a privilege. Steve Vincent for the people, P 71917.
Good afternoon, Your Honor. Justice Shive, P number 81798, on behalf of Mr. Owens, who has formal reading, understands his constitutional rights and stands mute.
All right, not guilty plea will enter. As to bond.
Chief, arguably, this defendant knows how to get to court. He has prior convictions. He knows how these court proceedings work. I have a failure to appear. I have June 20th. That's when Judge Taylor ended up giving this cash bond. In addition to this, Chief, I have a warrant out of Westland right now for this defendant's failure to appear on a possession charge. He's got a $5,000 cash surety bond. He failed to appear actually at 3 different court dates in Westland. So I have the priors that shows he's gone to court, that he knows how to get to court. And I have this failure to appear, and I have the warrant out of Westland. We're going to ask you to continue this.
All right, counsel.
So, Your Honor, I don't have the information about that warrant in Westland. I was not aware. My client looked a bit confused when it was said, but I don't get all the information that people do. So that may or may not be the case, but I wouldn't know why he missed there. But for this case, he just missed court a couple of days ago. He was picked up during the traffic stop. He said he didn't have a way to get to court. That is not an excuse. He knows it's not an excuse. And he said, I'm not going to make excuses and I'm not lying. This is what happened, but but I know it's not an excuse. It's an explanation. He does live with his mother. He has 2 kids. He's a lifelong resident of Detroit. It's my understanding he's currently unemployed. So if the court is not able to release him without the tether, then we understand, but any cash amount's going to be unaffordable. So that's where we're at, Your Honor. But we've had the conversation of the importance of coming to work regardless of what may be happening. To my knowledge, this is the first KPS on this matter and the only KPS. So I leave the rest up to the court, but any bond amount's going to be unaffordable to him. And he does have 2 kids, Your Honor.
Whatever hurt the arguments, counsel. Court finds $1,000 KPS is an unaffordable bond. Bond will be set at 1,000 personal with a GPS tether. With a GPS tether, 10 p.m. to 6 a.m. curfew. Thank you.
Thank you.
Judge, can I put bond condition of no weapons, no firearms of any kind?
Yes.
Okay. Do you understand that, Mr. Owens? No firearms and no other dangerous weapons? Is that a yes, sir? Okay. Judge, can court dates are July 8, 2025. It is a probable cause conference followed by preliminary examination, July 14, 2025. Both matters are in front of Judge Taylor.
Okay. Thank you.
Thank you. All right. Thank you, Mr. Owens. The gentleman in orange, please say your full name, sir.
You need to get yourself together, sir. Step off the screen and finish eating.
What's your name again, sir?
Dr. Monroe Hardwick.
Thank you, Mr. Hardwick. Case number is 2205968-301. The charge is from August 10, 2020. Charge is assault with a dangerous weapon, also known as felonious assault. KPS is from May 28, 2025. Exam $30,000 cash from Judge Giles.
Appearances.
Good afternoon, Lisa Coyle appearing on behalf of the people.
Jessica Scheib on behalf of Mr. Hardwick, who has formal reading, understands his constitutional rights and stands mute.
Not guilty plea will enter in. Argument as to bond.
Your Honor, he was arraigned on this matter. It is from August of 2020. Originally, this case began in September of 2020. He was given a $5,000 10%. Then it was converted to a $5,000 personal with a tether. The complainant failure to appear in 21. It was reissued in 22, and it sat there till 2025. The complainant in this matter is his brother, and apparently there were some continuing issues with the 2 brothers. His original or his second reissued arraignment was a $25,000 personal on the 10th of May. He failed to appear for an exam on the 28th, and that is why he's given that cash. Your Honor, no objection to a personal bond of $25,000 being, and I would recommend a tether on this, because unless there's a good reason for his non-appearance 2 weeks later after giving a personal.
May I say something?
No. Defense.
Your Honor, so yes, I believe this may be a reissue, as I believe Ms. Coyle, did I hear you correct, Ms. Coyle? After the complaining witness didn't show up, it was reissued. So before it was reissued, my client was showing up to court, and I don't believe there was any capiases. Then when it was reissued, he did miss that court one time. He did indicate that he had a stroke. Now, my client is 65 years old. He does suffer from strokes, PTSD, many health conditions. And we were trying to make sure he got all his medications there. So those are not excuses. It's an explanation. To my knowledge, he's not on probation or parole or anything pending. He's a lifelong resident. He lives alone. There's no issue with the no contact with the complaining witness. I understand the court can reissue cases. I understand the complaining witness failed to appear. I just don't think it's fair when my client is showing up to court dates, something gets reissued, he's back at court. Yes, he has a duty to show up to court, but he had a situation, it's our understanding he had a stroke. And so this is where we're at, due to the fact that it's his only capias that we are aware of, and he was making it to court before, and he hasn't picked up anything new. I'm asking the court to consider that personal bond without the GPS tether, Your Honor.
Court haven't heard the arguments of counsel. Excuse me. Court finds $30,000 bond is unaffordable. Bond will be reduced to $30,000 personal and no contact provision. Thank you.
Thank you.
All right, that being said, Mr. Hardwick, court dates are July 2nd, 2025. It is a probable cause conference followed by preliminary examination, July 9th, 2025. Both matters are in front of Judge Giles. Understand that, Mr. Hardwick? Okay. Sir, you can step aside. Sir, please say your full name.
Wiley there.
Joseph Wiley Dan, Mr. Dan, I'm magistrate at Chatfield. Case number is 20056-37701. Charge are from January 2020. Count 1, license document / plates forgery. Count 2 is identity theft. Count 3 is operating motor vehicle while license is suspended, revoked, denied. Capias is from April 5th, 2021. Bond was set at $5,000 cash surety.
Steve Benson for the people.
Jessica Scheib on behalf of Mr. Dan, who is from a reading, understands his constitutional rights and stands me up.
Not guilty plea will enter in. As to bond.
Chief, the charges, they're non-assaultive, as you can see, and they wouldn't be concerning for the people, except for the fact that this defendant, 2 years after he ended up capiasing, he ended up getting pulled over for a DWLS for driving while license suspended at 36 District Court. I have August 23rd of 23. And then he failed to appear twice for the arraignment. So that's still on the books 2 years after he ended up failing to appear for this multiple charge license forgery, ID theft, DWLS. So, I mean, while he's failing to appear, he's continuing to drive, getting picked up by the police, failing to appear at the court for the same type of matter. Judge, I just wanted you to know that. I'll leave this up to you.
Court haven't heard the arguments of counsel. Court finds that the $5,000 cash bond is not an affordable bond. In this matter, stop shaking your head, please, sir. Court finds that the bond is not an affordable bond. Based on these allegations, there's no court doesn't find the defendant to be a danger to the community, or there's no complaining witness. He's just flight risk because he didn't come to court. He didn't come to court. He keeps driving. Then he doesn't come to court again. So, I don't know. We'll give it one more chance. 5,000 personal with a GPS tether, 10 p.m. to 6 a.m. curfew. Mr. Dan, if you don't appear for court for your PCC or your preliminary exam, When you get picked up again, you're gonna come back before me, and there won't be any more personal bonds. So we're gonna take some accountability for ourselves, and we'll get this case behind us one way or the other. So if the court has to keep you incarcerated, so they'll just keep bringing you to court, or you can bring yourself to court. So I'll let you decide how you want to proceed. But Magistrate Echarte is about to give you what your court dates are.
Your
And
Honor.
you're gonna, well, no, we're not gonna act like that's what you do. You don't come to court, but you're gonna get your court date, and then hopefully you're gonna abide this time, because if you don't, and if you miss them, and when we do this again, there won't be a personal bond. Do you understand that, sir?
Yes, Your Honor.
Okay,
Yeah,
Magistrate
yeah.
Echarte.
Your Honor,
Okay.
we appreciate the personal bond, but there are important things I have to put on the record.
All right, that's fine. I'm just saying, for this felony case, he has a personal bond with a GPS tether, 10 p.m. to 6 a.m. curfew. With any other conditions that you want to put on and taking care of the traffic matter, that's on you. And
Y-
as far as going.
Your Honor, before you leave, I think it's important. I didn't get to place a record or make an argument. First of all, my client turned himself in.
Oh, I'm sorry. I thought you. My bad.
It's okay, sorry. So may I,
Yes, please.
Okay, so first of all, he turned himself in. So he took those steps to do that, and he's before the court because he turned himself in. Another thing is I looked at the register of actions after speaking to my client about why he was missing court. If we look at the date of this, Your Honor, it's from 2020, and it doesn't get entered until March 17, 2020, which is right before the court shut down, and he was at that court date. And then after that, I looked at the register of actions, and his court dates got adjourned probably 5 times minimum. I'm looking at it right now due to the court being closed, and we know that it kept getting adjourned. So when he finally has the next court date, which is in 2021, which is the time that it was going to be scheduled after the court stopped adjourning it due to COVID, that is the one that he misses, which could have happened for multiple reasons. And I understand that's 2021, but then he took the steps to turn himself in. So we appreciate the personal bond, and he heard every word you said, that regardless of him turning himself in or regardless of the pandemic, he has to be in court, and all of that still applies. But I'm asking the court, given that he turned himself in, and given that I looked at the register of actions, and that was the first time he missed after this was adjourned multiple times, I'm asking the court to reconsider the tether.
And this is why the defendants are so lucky to have attorneys like Ms. Scheib. That's why I brought up 2.5 years later, when this defendant ended up getting pulled over for a DWLS, then failed to appear twice for an arraignment. So while he knew that case was going on because he had gotten arraigned, and Ms. Scheib's correct, for over a year, these things were getting postponed. But then he got notice of the fact that case was still continuing because it was never dismissed. And then 2.5 years later, he's still on the roadway, driving without a license, also without insurance, which is, the culprit for why the insurance rates are so high in the city of Detroit, people driving without insurance. So the judge, again, I'm going to leave it up to you, but I just felt compelled to respond to that.
And thank you for the arguments on both sides. And the bond will be set where it is, with a personal bond, with the tether, and the 10 p.m. to 6 a.m. curfew. Thank you very much.
Thank you, Your Honor.
See you, Judge.
Thank you.
And Mr. Dan, the court dates are July 2nd, 2025, probable cause conference, followed by preliminary examination, July 9th, 2025. Both matters are in front of Judge Giles.
Your Honor, could we make sure his file is marked medical while he's waiting for that tether, please? He needs his medication.
Sure. All right, DDC, can you mark Mr. Dan's file medical?
Thank you, Your Honor.
And I will see you on the female side.
Magistrate, would it be safe to assume at this point that Ms. Parker, the defendant from MDOC, that's not going to be going this morning?
Nope, it's not.
Okay, thanks.
Okay. So I will see DDC on the female side. Let me do this paperwork for $1,000. All right. That's for Mr. Dan. Let's do Owens. $1,000. UPS tether. Curfew. 10 p.m. 6 a.m. And this for Judge McConnell. Not for. These are for Judge McConnell. McConnell, 1,000. Tether, curfew, 10 p.m. to 6 a.m. Chemical. I still have the traffic matters on these individuals. I'll do those. Let's do the females. This goes to Mr. Dan's file. Put that in there. DDC, can you unmute? And which, Council Shy, please unmute.
Yes, Your Honor.
Okay. The young lady at DDC, what's your name, ma'am? Young lady at DDC, what's your name?
It's hard to hear
Let's
her.
try this.
I think it's Ms.
I didn't
Michael.
hear your name. Is your last name Michael? Yes, how are you, Michael? Thank you. Ms. Michael, a magistrate at Chartea. Not only do you have a criminal matter, but you have misdemeanor matters. And the misdemeanor matters, we're going to recall the warrants. You're getting a personal bond. Nobody has to pay any money for you to get out of jail. The maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. Let me tell you what the misdemeanor matters are. First ticket is P1327537. Driver's license never acquired, no insurance misdemeanor. Next ticket is P1374846. Driver's license never acquired. Next ticket is P1507709. Driver's license never acquired. Next ticket is P1519674. Disorderly conduct. Last ticket is SP1045, SP104857771. Failed to display valid driver's license, not on person. I'm going to enter plea of not guilty. Court date is July 7th, 2025. pretrial as well as review in front of Judge Wagner. Okay, Ms. Michael, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, ma'am?
Yes, ma'am.
Okay, now criminal matter, case number is 24058530001. Please say your full name.
Harriet May Michael.
Thank you. Counsel Shive, you wait for my reading, stand mute.
Yes, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court dates are July 8, 2025, probable cause conference, followed by preliminary examination, July 14, 2025. Both matters are in front of Judge Taylor. Okay, let's see. Okay, while this case is pending, Ms. Michael, you are not to go back to the, let's see. You're not to go have any contact with the location on Penrod. Do you understand that, ma'am? 12017, excuse me, 12010 Penrod.
Okay.
Okay. Counsel Coyle, go ahead, ma'am.
Lisa Coyle, appearing on behalf of the people. I'm not aware of a criminal history for Ms. Michael. This is quasi non-assaultive. No objection to it. Back from November of 23. No objection to a 10,000 personal bond. Also, no contact with Ms. Pincham or the Penrod Street address. Thank you.
No objections, Your Honor.
Okay. So while this case is pending, Ms. Michael, no contact with a Priscilla Pincham and no contact with the Penrod location. Do you understand that?
Yes, ma'am.
Okay. You're gonna get a $10,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that, ma'am?
Yes.
All right, that concludes your arraignment. You can step aside. What's your name, ma'am?
I'm Ms. McBride.
Ms. McBride, this magistrate at Chadafea, not only do you have a criminal matter, but you also have misdemeanor matters where you did not show up for court. On the misdemeanor matters, you're gonna get a personal bond. Nobody has to pay any money for you to get out of jail. Maximum penalty on each misdemeanor is up to 93 days jail and a $500 fine. Let me tell you what the tickets are. First one is P11888368, driving unregistered untitled vehicle, no insurance misdemeanor, failed display valid driver's license, not on person. Last ticket is P12188053, driving unregistered untitled vehicle, driving while life suspended. I'm gonna enter a plea of not guilty. Court date is July 7th, 2025, pre-trial in front of Judge Wagner. Ms. McBride, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, ma'am? Is that a yes?
Yes, I'm sorry, I said yes.
Thank you, ma'am. All right, let me give you criminal matter, case number 24059108001. Please say your full name again.
McBride.
Okay. Counsel Shive, you wait for my reading, stand mute.
Yes, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are July 3rd, 2025, probable cause conference, followed by preliminary examination, July 10th, 2025. Both matters are in front of Judge Jefferson. Okay, Ms. McBride, let me tell you a couple of things. There is no drinking or possessing any alcoholic beverages. There is no driving without a valid driver's license. Do you understand both of those matters?
Yes.
Okay, Counsel Vincent, go ahead with your recommendation.
Thank you, Magistrate. I see this incident date, September 24th of 22, lien entered August of 2024. We're still asking for a 5,000 cash surety. We're asking for an alcohol tether as well. First and foremost, I'll briefly get into the allegations, but this defendant has a warrant, and I checked this out. It's there. I got the case number 2001033SD out of Royal Oak for an OWI second. that she failed to show up for. So if she would have gone through that matter and then been found guilty,
I've handled that situation. I've been a court, I paid $500.
Ma'am, stop.
Okay.
You do have the right to speak, but let the attorneys, and you have a defense counsel that can speak on your behalf. And if at the end of everything you want to speak, that is your right. Do you understand all that?
Yeah.
Just remember, everything is being recorded. So anything you say, it could be used against you. Do you understand that, ma'am?
Yeah.
Okay, Counsel Vincent, go ahead again.
Thank you, Magistrate. Defense counsel may have, different information, but I just looked in my court this morning and found it. I have the case number, but at least what my court reflects is that there was an OWI second that this defendant was charged with that she failed to appear on. She had a $5,000 cash surety. I have an offense date over there of August 30th of 20. So as you can see with the August 20th date being charged with the OWI second, and here being charged with the OWI second, potentially this could have been a third if she went through the adjudication process over there. But on top of that, Magistrate, we have these allegations, which are just really troubling. We have an individual who's allegedly driving the wrong way on Woodward near 8 Mile, the wrong way where she's driving to, traffic that's coming at her. One of those people being a police officer. They had to swerve so they didn't crash with her head on. Apparently, there were other vehicles on the road that also had to swerve to avoid this defendant. She was driving with a beat up tire. And then ultimately, when she was stopped after the police tried to stop her for 3 or 4 minutes, the preliminary PBT, she ended up blowing a .224, going the wrong way on Woodward, and a .22. And then after arrest and conveyance to the Detroit Detention Center, a second breath test, at least as I read it, was performed, and she had a .19 and a .18. So with her history, with the allegations that are serious here, we're asking for that cash bond. And Magistrate, I know how you look at these things, so I do affirm the fact that this was a later 2022 incident, but with the history and what's going on with warrants and the allegations, we think a cash bond with an alcohol tether is appropriate.
Okay, and Counsel Vincent, just briefly, from 2022, did she have any more drinking and driving cases?
I didn't find it.
Okay, thank you. Go ahead, Counsel Scheid.
So, Your Honor, that's correct. It is now almost 3 years later. We're not aware of any incidents whatsoever. A whole 3 years later, my client is not on probation or parole. There is something that she handled, that she took care of, that she paid $500 for. She's already taking care of that matter, took care of that matter, that the one that was brought up in Royal Oak. She has 2 jobs to support her 3 kids. She's a single mom of 3 kids. She has 2 jobs. Your Honor, she did do some college. She's a CNA med tech. She's a lifelong resident. There's no flight risk here. There's no KPS. I understand they brought something up from Royal. We don't have that information. It's my understanding she already took care of that. So, Your Honor, given that there has nothing in the 3 years that have passed, I'm asking the court respectfully to give her a personal bond so she can get out, continue to work, provide for her children. She'll take care of this. Absolutely no driving with a suspended license. She understands that. No drinking, no matter what the case may be, even though this is from 3 years ago. So given the age of the case, and given that she has not been convicted of this, she's not been convicted of anything after this, so I'm asking the court to consider a personal bond. She understands she needs to make it to her court date. She will be at her court dates, and she will comply with all court orders, Your Honor.
Thank you. Court's heard the representations, both sides. This particular matter, one other bond condition. Ma'am, there's going to be an alcohol tether. Okay, in this particular matter. And so I'm going to give you a chance, ma'am. I'm going to give you a $25,000 personal bond. Let me say the bond conditions: no drinking, no possessing any alcoholic beverages, alcohol tether, no driving without a valid license. Do you understand those bond conditions, ma'am?
Yes.
Okay. That concludes your arraignment. Thank you.
Thank you.
Thank you, Your Honor.
Ms. Davis, this is Magistrate Chatterbath. You have not only a criminal matter, but some misdemeanor matters. You did not show up. You're gonna get a personal bond. Nobody has to pay any money for you to get out of jail. Maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. First ticket is P1223230, driver's license never acquired. Next ticket is P1223238, no insurance misdemeanor. That's it. Next ticket is P854623, drama license not valid or improper license. Next ticket is P963626, allowing unlicensed driver to drive. Last ticket is PSP 9636261, allowing unlicensed driver to drive. And let me see, that's the same ticket. Financial plea of not guilty. Court date is July 8, 2025. It is a pre-trial at 9 o'clock. Let's see who's that in front of. I don't have it posted, so let's see. That's going to be in front of Judge Sherman. Okay, Ms. Davis, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Now, let me give you a criminal matter. Case number is 19045444701. Ms. Davis, please say your full name. Okay. Counsel Shive, you wait for Maureen, stand mute.
Yes, sir.
Financial plea of not guilty. Court date is July 3rd, 2025. Pre-trial in front of Judge Bryant. Ms. Davis, bond condition. You're not to have a contact with a Tiana Smith. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Understand that, ma'am?
Yes.
Okay. I will also indicate that on March 29, 2021, warrant was issued for your arrest. Failed to appear, bond was set at $500, 10%. Counsel Vincent, go ahead, sir.
Magistrate, you initially arraigned her in October of 20, and then she failed to appear. I did read some notes in the, in defense of the defendant, and I'm sure Ms. Shive would bring this up. I think the parties had made amends here. I do appreciate the no contact, though, just erring on the side of caution. But with all of that being said, Magistrate, we're not going to object to a personal bond at this time.
That being said, I know Counsel Shive was not going to object. So, ma'am, I'm going to give you a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that, Ms. Davis? Okay, but please, while this case is pending, stay away from Tiana Smith. Okay, thank you. I believe that concludes Ms. Davis's arraignment. EDC, thank you very much. See you later on for the afternoon session.
Good afternoon. Thank you.
Right. See you.
Thank you, folks.
Thank you.
Yep.